All right, welcome to the Expert Witness Guide Training, Module 1, General Principles, Lesson 2, the relationship between the courts and expert witnesses. This is a continuation from yesterday on our first module. Yesterday we did the nature and purpose of expert evidence. Today we'll do the relationship between the courts and expert witnesses. We are going to take out the case references and footnotes in these modules. The Expert Witness Guide has a fuller rendition of the information that's made available in the training course. So if you want case references, or if you want additional information, please have a look at the Expert Witness Guide. That is really expands on what is contained in this course. We'll do the fundamental principles in this course, but if you want more information, you can have a look at your Expert Witness Guide. Okay. Let's have a look at the relationship between the courts and expert witnesses. This is an important topic today. You know, at the heart of what you're doing as an expert is this relationship with the court. If you can get your relationship with the court right, you're going to be able to persuade that judge. So if the court accepts that you're a credible, unbiased witness and that you're right in your reasoning, the court will accept your evidence. As simple as that. So let's have a look at the trustworthiness question here at the heart of the evidence. At the heart of the trustworthiness of expert evidence lies the notion of the independence of the expert. The duty of experts to help the court on matters within their expertise overrides any obligation to the person from whom experts have received instructions or by whom they are paid. And this is a topic that comes up so often. And experts want to know, but I'm supposed to be unbiased, but my attorney wants me to find in their favor. The answer lies in the quote which we're going to look at in a moment. But the bottom line is that you have to be independent, you have to be trustworthy, and you have to give objective evidence. That doesn't mean that you don't argue your case. You argue the case strongly based on the correct reasoning and on an objective assessment of the facts. This is the correct position. You don't go and defend a case that you do not believe is in fact accurate and correct. So expert witnesses should therefore provide their independent assistance by way of an objective, unbiased opinion in relation to matters within their expertise, and should never promote one side's case at the expense of their independence. I want to have a look at a quote by Davis, J. and Schneider and others. He says the following: in short, an expert comes to court to give the court the benefit of his or her expertise. Agreed, an expert is called by a particular party, presumably because the conclusion of the expert, using his or her expertise, is in favor of the line of argument of the particular party. But that does not absolve the expert from providing the court with as objective and unbiased an opinion based on his or her expertise as possible. An expert is not a hired gun who dispenses his or her expertise for the purposes of a particular case. An expert does not assume the role of an advocate, nor gives evidence which goes beyond the logic which is dictated by the scientific knowledge which that expert claims to possess. In other words, there, captured in a nutshell, is the essence of the expert's duty to the court. In order to be taken seriously, you must demonstrate objectivity. What I would add to that quote is what I've said earlier, is that within the parameters set out within that quotation, it is absolutely up to you to defend your position, to correctly and rationally advance your argument on correct facts and correct logic. But you cannot be biased in arriving at that conclusion. There's a big difference between the two. Let's have a look at the expert witness's duty to the courts, which in some respects is similar to legal representatives' duties. So the expert witnesses' duties to the courts and to the public stand on a similar footing to the duties owed to the courts by attorneys and advocates. So by actual officers of the court. It's quite an interesting way of looking at it. There's a lot of merit in this. Each undertakes a duty to provide services to a client. In each case, those services include a paramount duty to the court and to the public, which may require the attorney, advocate, or the expert witness to act in a way which does not advance the client's case. The expert witness must give evidence impartially and objectively, even if this involves concessions that are contrary to the client's interests. In this regard, the relationship which the expert witness has with the courts has more in common with the relationship between the attorney and the advocate and the courts than it does with the witness of fact. So there's this special relationship which includes this paramount duty to the court and to the public. So you're not just called for one side. You can't just say what you want. You have a duty to the court as an expert, and you have a duty to the public as well as a duty to your client. Let's have a look at the sanction 1.2.3, sanction for breach of expert witnesses' duties. Expert witnesses, in addition to their duties to the courts, owe the party retaining them a contractual duty to exercise reasonable skill and care in performing their mandate. So very important here. So expert witnesses have got a duty to the court, similar to an attorney and an advocate, but they also have a duty to their clients to exercise reasonable skill and care in performing your mandate as an expert. Similar to a doctor in that way. You must comply with reasonable standards of professionalism as an expert. The legal relationship between the expert witness and the client is created by contract. The expert witness undertakes to render professional services, and the client undertakes to pay for services rendered. It is an implied term of the contract that the expert witness, in performing the contract of mandate, will exercise the reasonable skill and care of an expert witness in the particular field. If the expert witness fails in that duty, the expert may be liable to compensate the client for damages caused by the breach of the contract. So underlying this relationship between the client and the expert is a contract. And that means that the contract provides implied terms, doesn't even have to expressly say so. But inherent in that contract is that the expert will use reasonable skill and care in coming to his or her conclusion. And in the UK, I'm not aware of any case in South Africa similar, but in Jones versus Caney, a decision of the United Kingdom Supreme Court, so that's a very high court, it's their most senior court. The court considered proceedings for negligence against an expert witness retained by the claimant. The clinical psychologist, who was the expert in question, signed a joint statement, very similar to our joint minute, which wrongly recorded that she agreed that the appellant had not suffered PTSD, and that she had found that the appellant to be deceitful in his reporting. So she was wrong in making that statement. The plaintiff sued the clinical psychologist on the basis that she had carried out this task negligently. It was claimed that this conduct by the expert witness was so damaging to his claim for damages that he felt constrained to settle the matter for a significantly lower sum than he might otherwise have been able to achieve. The court held that the expert witness did not enjoy immunity from being sued for negligence and could be sued. So, typical situation where the expert's opinion, this is the plaintiff's own expert, the case against the expert was that then was an important factor in inducing him to settle for a lower amount than he should actually have settled for because the expert's opinion was negligently granted. And the court in that case said that the expert could be sued. It was a preliminary point, but at that stage the court said that the expert could be sued for negligence. So that's an important case to be aware of. Then let's have a look at the test for lack of bias. The independence of the expert witness should be assessed by applying the following test of independence. Would the expert provide the same opinion if given the same instructions by another party to the litigation? Quite an interesting question that to ask yourself. Nice test for whether you're being biased or not. If you can say you would have provided the same opinion if you were briefed by the other side or instructed by the other side, then that is the litmus test for you not being biased. Let's have a look at the next point, the role of the court regarding the facts. This becomes very important in the context of joint minutes. We will look at this now, also when we get to joint minutes in pre-trial preparations. But be aware of the following. The role of the court regarding the facts. The general principle is that it is the function of the court to decide the facts on any issue in dispute. The only category of exception is when the parties agree on the facts. This starts becoming important for experts. But remember, for now, we're just setting those building blocks in place. For now, the general principle is that the court will decide the facts. General principle. But there's an important category of exception when it comes to expert evidence. That category of exception is when the parties agree on the facts. And that, in the context of personal injury cases, means that includes where expert witnesses agree on the facts. Those facts are then what we call common cause between the parties, and it is no longer the function of the court to decide those facts. So you can start seeing that the general approach is the court will decide the facts, but when experts agree on certain facts, that removes those facts from the scope of the inquiry which the judge makes, and those facts are then agreed on by the experts. Can be tremendously important in a case. So one has to keep that firmly in mind as an expert. And just to go back to that slide, just one more point that I want to make. When we get to joint minutes, remember in expert evidence, it's not only an oral say-so, but that agreement between the parties is recorded in a joint minute. So you can see that that principle becomes very important when we look at joint minutes later. Okay, let's have a look then at the court's approach to questionable expert evidence. The application of the fundamental principles of the adversarial system requires the appropriate management of questionable expert evidence. In South Africa, we have an adversarial system. In other words, each side instructs attorneys and they fight it out. There are certain rules that apply, but generally, we don't have what's called an inquisitorial system. In other words, the judge doesn't investigate the matter and make a decision. The judge is more in the role of an umpire who sort of sits back and makes sure that the game is being played fairly, but it is up to each side to tackle the other side and to try to win the case that way. And therefore, it is not the function of the court to develop its own theory or thesis and to introduce of its own accord evidence that is otherwise founded on special knowledge and skill. So, very important. Remember I said a minute ago that our judges are not inquisitorial in their conduct. It's an accusatorial system. In other words, because the judge doesn't go in and conduct an investigation, the judge's powers in that regard are actually limited. And they are limited to a large extent to sitting back and letting the parties take each other on. And therefore, when it comes to expert evidence in particular, the judge can't just come up with his or her own pet theory about the particular issue at hand and then impose that theory on the parties. No, the judge must hear the respective theories by the experts and then decide in accordance with the rules of the game. So that gives and it's in part because of that reason that the expert fulfills such a trusted role in court, because they're dealing with matters that are within their domain, and the judge has in this respect has quite limited powers to get involved and investigate. They can ask certain questions, they can clarify, but they can't conduct their own investigation. Just to continue on that previous point, where the judge considers an expert's agreed conclusion to be questionable, he or she should exercise very great caution in how the expert evidence should be handled. Very important. The judge cannot just go barging in. They have to be very careful where they're questioning the expert's conclusion. It is essential for the judge to give notice of any misgivings to the parties as soon as possible in the course of the trial. As soon as it becomes an issue that the judge regards an expert's agreed conclusion to be questionable, in other words, agreed between the parties, the judge must notify the parties. The attendance of the expert in question should be secured in order to explain his or her position. So if the expert is not there and you're just going on an affidavit or some other agreed process, expert witnesses are not there, the judge should give notice. I have a problem with this conclusion, even if it's agreed in the joint minutes. Please get the relevant expert or experts here. I want to give them a chance to explain themselves. Or in other similar situation where the expert is actually in the witness box, the court must still put the judge's misgivings to the expert for the expert to deal with those misgivings. That can't just suddenly be surprised on the expert at the judgment stage. That is simply unfair and should not be allowed. This should be done during the trial itself. The trial court's judgment is not the place to reject the expert's opinion agreed between the parties, nor to introduce a theory at variance with the parties' agreed position. In other words, when your two sets of experts have their respective positions, whether agreed or not, those are the parameters of the dispute before court. The court cannot then introduce its own pet theory without some foundation by the experts. If the judge wants to question, they must then allow the experts an opportunity to respond. And certainly what the judge most definitely cannot do is to, at judgment stage, inject into those proceedings his or her own opinion without having allowed the parties to ventilate that dispute properly before him or her. Very important. Then 1.2.8, powers of court regarding agreed opinion. Where two or more experts meet and agree on an opinion. Now this becomes important, particularly within the context of joint minutes. Although the parties are not at liberty to repudiate such an agreement placed before the court. In other words, when you place that agreement before the court, the parties are, as a general rule, bound by the agreement. But it does not follow that a court is bound to defer to the agreed opinion. In other words, it doesn't follow that because the parties are bound, that the judge is bound. There's a big difference. The parties may be bound to an opinion, but if the judge has a problem, he or she is not bound. A court may reject an agreed opinion on any of a number of grounds, all amounting to the same thing. That is, the proffered opinion was unconvincing. Right, now remember, we're looking at the relationship between the courts and expert witnesses. Now, if you look at yesterday's video and if you look at the video today, you start understanding the power balance, if you like, or put slightly differently, the correct roles between the various parties. So you've got the experts. They have a duty to the court to advance their reasoning, to establish their expertise. We've looked at all of that. That's their role, is as a trusted guide. Even where they agree on facts, that court is, however, not bound by their opinion. The court's role, although it is the role of more of an umpire, it will sit back and allow fair play to take place and will not conduct an inquisitorial assessment of the case. However, the court must, as part of its duties, be satisfied as to the essential reasoning of the agreed opinions of the experts, or agreed facts either, but certainly the agreed opinions in this particular point. So the judge must be convinced as to the reasoning process. This is a very, very important role of the judge. And what flows from that, for practical purposes, it's very important to realize this is the role of the expert, is to allow the judge to follow the reasoning process, allow the judge to understand the argument and to rely on that argument. And if you get that right, and if you correct on your expertise, if you correct on your facts and you correct on your conclusion, the judge will follow your opinion. You will be successful. So that, in more detail now, is a development of the point we looked at yesterday. The expert witness is a trusted guide to the court. Now, let's just develop that point even further. So, the court must assess the process of reasoning. This is really the essence of what happens with expert evidence. Incidentally, it's why I love working with experts, because at the heart of the case is a process of reasoning. You're taking a dispute between human beings and you are subjecting it to a reasoned process in order to resolve that dispute, and that is at the heart, to me, of the rule of law. So even where experts agree on a matter within their joint expertise, that is merely part of the total body of evidence. The court must still assess the joint opinion and decide whether to accept it. The court must analyze the process of reasoning which led to the expert's conclusion, including the premises from which that reasoning proceeds. The court must be satisfied that the opinion is based on facts and that the expert has reached a defensible conclusion on the matter. The court will assess the process of reasoning. And then just the duty of the court on questions of law. Parties to legal proceedings cannot, by their agreement, compel the court to decide the case on an incorrect legal basis. Legal issues are for the court to decide. This principle is, however, restricted to agreements or concessions as to the law, not facts and expert opinions. And we've looked at the facts and expert opinions. But when it comes to the law, then the court cannot decide a case on a wrong legal basis. That is not for the experts, and indeed not even for the legal representative to decide for the court. The court will decide that themselves. Okay, and then to wrap up, still busy with Module 1 or Chapter 1 of the textbook. We've just had a look at the relationship between the courts and expert witnesses. So important. And now we're going to tomorrow we're going to turn our attention to establishing the right to give expert evidence. Thank you very much for your time, and I will see you in the next video.